build this throughout the next several years.
We're talking about the 20 megawatt Remington facility. That's going to be built starting.
That's correct.
Okay. It's not going to be systematically built over.
Right, obviously you build it, you make the investment, and then you get your return over time for customers.
And so those facility costs are recovered from customers over that time period, regardless of what solar prices in the market do. And would you agree with me that if the company were to enter into a PPA for the output of a 20 megawatt solar facility, those PPA costs would be recovered from customers through the company's fuel factor?
Yes.
And fuel and purchase power costs that are recovered through the fuel factor are recovered on a dollar-for-dollar basis with no rate of return?
The return on a PPA would be through, I mean, obviously the developer has a return in his financials. So there's still a return embedded in the price of the PPA.
So there would be a return for the developer, but there would be no return for Dominion's shareholders.
That's correct.
So would you agree that it would be better for Dominion's shareholders for the company to build the Remington facility as opposed to entering into a PPA for 20 megawatts of solar energy and capacity?
I mean, we're always looking to do what is in the best interest of customers. And that gets into, there's a lot of factors to play into that. And again, it's not that there isn't a return, it's just whether it's company owned or the return is in the developer.
Mr. Gaskill, my question was, would you agree with me that it would be better for Dominion's shareholders for the company to build and own the Remington facility as opposed to entering into a PPA for third party?
All else being equal, they could be, yes.
Okay. And Mr. Gaskill, still staying on this topic of the company's consideration of third-party alternatives, which is required by law. Do you recall the last time that the company sought a CPCN and cost recovery to build a new generation facility?
Last time we filed was July 1st for the Greensville combined cycle.
Was it the commission's order approving the Brunswick CPCN? Was that the last time the commission approved a company's request for a CPCN?
I believe that's correct.
And are you familiar with that proceeding before the commission? You know that it was a subject of debate at that hearing whether the company did adequately look at third-party alternatives to building Brunswick.
It was, yes.
Remember that? Do you recall that the hearing examiner in that case recommended the commission should reject the Brunswick application because, in her opinion, the company did not consider third-party alternatives?
I think my recollection of the case, there were specifics to that we were proposing roughly 1,300 megawatt combined cycle. We did have third-party market alternatives. However, I guess in aggregate they added to roughly 1,000 megawatts, and they were existing combined cycles versus new. So I think the issue there was not that we didn't do a market test, also the applicability of the test that we did, and whether it was adequate to, so really the size and the nature of the alternatives that we were looking at.
Okay. And do you remember that in that case, the company put forward evidence of consideration of PJM market prices that could have been used as an alternative to the Brunswick facility? Now, the hearing examiner recommended that the commission should reject the company's application, but the commission didn't agree with the hearing examiner, did it?
The commission approved the project.
The commission approved the CPCN. And did you review that final order? I put the commission's final order in the Brunswick CPCN case, which is case number PUE 2012-00120 on the screen. And I just want to ask you about a couple statements on this point that the commission makes on page 17 of that order. And you see on page 17 here that the commission references a new legal requirement for CPCN proceedings.
They do,
Did
yes.
you see that? And you see that the commission quotes the statute here, which is that, quote, "A utility seeking approval to construct a generation facility shall demonstrate," and that's the commission's emphasis, "shall demonstrate that it is considered and weighed alternative options, including third-party market alternatives in its selection process."
Yes, they're quoting the statute, and we have complied with that in this case.
And the commission said that law wasn't applicable to the Brunswick case, but it will affect CPCN proceedings in the future, right?
It is, and if you go up, I think it's about 2 pages, maybe to page 15, the commission order actually expounds on the fact that they have not and are not specifically requiring an RFP. So they are acknowledging that there are multiple ways for the utility to demonstrate that they have considered and weighed alternatives. An RFP is certainly one way to do that. It's not the only way.
And do you see here that the commission said, quote, "Under this new statute, the CPCN applicant no longer has the option of trying to prove its case without evidence of consideration of actual third-party alternatives in its selection process." Do you see that? Do you agree with the commission's statement here that Dominion cannot prove its case today without evidence of consideration of actual third-party alternatives?
That is what it says, and we have considered actual third-party alternatives in this case.
Okay. And you talk about company's consideration of alternatives, again, on page 13 of your testimony, is that right?
Yes.
And I want to ask you about your testimony, but I want you to refer to a discovery response here that I'm going to hand out. Mr. Gaskill, I've put on the screen and handed out question number 15 from the Attorney General's second set of interrogatories in this case. And you see here that the company was asked to provide the results of any RFP or other formal solicitation conducted by the company in its analysis of alternatives in this case. And you signed this discovery response?
I did.
And you said in this response that the company didn't do an RFP.
That is correct for this case, yes.
You said instead that the company primarily relied on projects in North Carolina for the purposes of evaluating third-party market alternatives.
Right. We have, down in my direct testimony, 147 megawatts from 24 actual PPAs that we have signed in North Carolina. To date, it's a little over 300, roughly 50 PPA contracts with solar in our North Carolina load service territory.
And you said you looked at similarly sized solar facilities in North Carolina, correct?
That's correct.
Okay. And in your direct testimony, Schedule 1 to your direct testimony, you actually list a series of North Carolina solar projects that the company evaluated in its
So, yeah, let me clarify. I mean, there are 2 different ways that we are looking at the solar projects in North Carolina. One is with the actual PPAs that we have. Those range from, say, 5 megawatts to 20 megawatts. And then what this schedule is looking at is the capital cost of development of what we screen this of looking at the last 6 months of fixed tilt solar in our service territory and the capital cost that they identified. So it's really 2 different tests of market alternatives. One is to ensure that our capital costs for our project are in line with the market, as well as when we look at the energy and capacity benefits of this project, do they align with the capacity and energy benefits of the actual PPAs that we have in place in our load service territory.
Okay. And you didn't attach any of the terms of those PPAs to your direct testimony, did you?
No, they are, it is publicly available. It's a public tariff, Schedule 19.
Okay, so what you attached to your direct testimony, what the company submitted for the record here today, was a list of projects in North Carolina.
Yeah, if you go back to my page 13, line 10, you'll note I described the PPAs that we've actually described, and then on line 10 I say in addition. So what I'm denoting is there are two different ways that we are comparing this.
Okay, and I want to get back to that in just a minute, but I want to ask you about what is attached to your direct testimony, which is Schedule 1. Would you agree with me that this is a list of solar projects listed by size of the facility, megawatts, and cost per kilowatt?
Yes.
And would you agree with me that 26 out of 27 of these projects are 5 megawatts or smaller in size?
They are. They're still, utility scale solar projects. Yes.
Utility scale, but 5 megawatts is a lot smaller than 20 megawatts, right?
It is, but I think the relative cost between going from 5 to 20, while you get some economies of scale, it's still an applicable comparison, particularly in light of the fact, if you'll note that there's probably only, say, a half dozen different developers on here. So one developer may come out and develop a number of 5 megawatt projects, and they're all going to be within a fairly narrow geographical region. They can still achieve many of the economies of scale from their EPC and that sort of thing. So very much so, this is a valid comparison to check the reasonableness of our capital costs for Remington.
Okay. And Your Honor, before I forget, I'd like to have marked this discovery response question number 15.
Certainly, the Consumer Counsel's second set of interrogatories, question number 15, and the response will be marked and admitted as Exhibit 11, subject to further examination.
Okay, Mr. Gaskill, let me get back to your Schedule 1 for a minute. You would admit, though, that there are some economies of scale, that as the size of a solar facility increases, the cost on a per kilowatt hour basis is going to go down.
It can, yeah, and again, I think a lot of these developers will still be able to achieve that by developing multiple projects at the same time within a fairly narrow geographical region.
And we said that 26 out of 27 of the projects on your Schedule 1 are 5 megawatts or smaller. The only one that's larger than 5 megawatts, would you agree, is this 14 megawatt project by Sun Energy One LLC, is that right?
That is correct. I will note, probably subsequent to filing this, if we went and updated this list today, there would be a number of 20 megawatt projects that also list really their capital cost range in the same 2,500 or so.
So the one project on this list that's larger than 5 megawatts has capital costs of $23.57 per kilowatt, correct?
That's correct.
And that is essentially the same cost per kilowatt as Remington's $23.50, right?
It's very similar, yes.
And this is just a list of solar projects that have gone forward in North Carolina. This is not representative of offers received by the company, is it?
That's correct. To date, we have only received, at least on a utility scale, one offer for Virginia-based solar. And that's the one that we discussed earlier in the Amazon.
You didn't try to negotiate a PPA price with any of these developers, did you?
Those PPAs are at the Schedule 19 avoided cost rate in North Carolina.
And as you just said, there's a cost rate in North Carolina, so there are requirements for what utilities must. So the regulatory structure is different in North Carolina, would you agree?
With respect to PERCO, yeah.
Okay, so utilities have to buy solar projects 5 megawatts or larger in North Carolina.
5 megawatts or smaller.
Excuse me, yes, 5 megawatts or smaller. Okay. Now, just going back to this idea of alternatives, would you agree with me that if Dominion were going to consider purchasing energy and capacity from some developer, Dominion would want to know